The Supreme Court of the United States, SCOTUS, is the highest judicial authority in the country. It serves as the final arbiter of constitutional law and federal statutes, ensuring the uniform interpretation and application of the law across the United States. Below, we explore its structure, functions, significant roles, and procedures. Structure and composition. 1. Justices number. The Supreme Court consists of 9 justices, including 1 Chief Justice and 8 Associate Justices. Appointment. Justices are nominated by the President and confirmed by the Senate. Tenure. Justices serve lifetime appointments, although they can resign, retire, or be impeached and removed. Administrative support includes librarians, administrative assistants, and other personnel who help in the smooth functioning of the court. Functions and powers. 1. Judicial review. Definition: the power of the Supreme Court to review laws and actions by federal, state, and local governments to ensure they comply with the Constitution. This authority was established in the landmark case Marbury v. Madison, 1803. 2. Interpreting the Constitution role. The Court interprets the Constitution and helps shape its understanding through its rulings. It addresses issues of constitutional rights, freedoms, and the limits of government power. 3. Final Court of Appeal. Appellate jurisdiction. The Supreme Court serves as the highest court of appeal, reviewing cases from lower federal courts and state Supreme Courts. It does not conduct trials, but reviews the records and decisions of previous proceedings. 4. Original jurisdiction. In certain cases, such as disputes between states or cases involving diplomats, the Supreme Court has original jurisdiction, meaning it can hear the case first without it having been heard by a lower court. Procedures of the Supreme Court. 1. Petition for writ of certiorari. Certiorari. Most cases reach the Supreme Court through a petition for a writ of certiorari, where parties request the court to review the decisions of lower courts. Rule of 4. At least 4 justices must vote to grant certiorari for the case to be heard. 2. Briefs and oral arguments. Briefs. Once certiorari is granted, both parties submit written briefs outlining their arguments and legal justifications. Amicus curiae briefs may also be submitted by interested third parties. Oral arguments. Lawyers from both sides present their arguments in person before the justices, who may ask questions and seek clarifications. 3. Conference and deliberation. Private conference. After oral arguments, justices meet in private to discuss the case, where each justice may express their views, and an initial vote is taken. Opinion assignment. If the Chief Justice is in the majority, they will assign the writing of the court's opinion. If not, the senior justice in the majority will assign the opinion. 4. Opinions of the court majority. Opinion reflects the official ruling of the court and the rationale behind the decision. It is binding precedent. Concurring opinion, written by justices who agree with the outcome of the majority opinion but for different reasons. Dissenting opinion, written by justices who disagree with the majority decision. These opinions, while not legally binding, can influence future legal thinking and rulings. 5. Issuance of the decision. Public announcement. Once opinions are finalized and signed, the decisions are announced to the public. They are also published in the United States Reports, the official record of the court's rulings. Significant cases. 1. Marbury v. Madison, 1803, established the principle of judicial review. 2. Brown v. Board of Education, 1954, declared state laws establishing separate public schools for black and white students to be unconstitutional, effectively ending racial segregation in schools. 3. Roe v. Wade, 1973, recognized the constitutional right to privacy, extending to a woman's decision to have an abortion, subsequently adjusted by later rulings. 4. Obergefell v. Hodges, 2015, recognized same-sex marriage as a constitutionally protected right. 5. Citizens United v. FEC 2010 held that the Free Speech Clause of the First Amendment prohibits the government from restricting independent expenditures for political campaigns by corporations, associations, or labor unions. Conclusion: